Good morning. May it please the Court, Tom Fitzpatrick on behalf of the defendants appellants. With me is my colleague Gary Matsko. The Superior Court's second amended judgment in this case should be reversed because the trial court's findings of fact compelled certain very significant legal rulings. One, that the plaintiff, Bernard Pointer, had usurped the corporate opportunity that was referred to in the case as the Milford Outline Plan. Two, that Mr. Pointer had engaged in self-dealing in connection with his acquisition of Fletcher Granite's 64-acre real estate parcel in Milford. Three, that Mr. Pointer had breached his employment contract with Fletcher Granite. And finally, four, that Mr. Pointer was not frozen out of Fletcher Granite in light of his persistent and varied misconduct, all detailed in the findings of fact of the trial judge. And returning to the first issue, the issue of the usurpation of the corporate opportunity.
Which opportunity is that? Is that the real estate development opportunity?
This is the yes, the Milford real estate opportunity.
I thought the partnership had no interest in real estate development.
Well, there were, to clarify, there were two corporate opportunity claims. One which we've abandoned on this appeal, and one that we're pursuing. The one that we are not pursuing on appeal was the Greystone residential real estate development in Westford, Massachusetts. We are claiming that the court's findings of fact with respect to the Milford, Massachusetts outline plan, that corporate opportunity was usurped, and that the judge's findings of fact relating to that corporate opportunity required a finding of breach of fiduciary duty. But to your point, Justice Cordy, the judge does find that the other managers had expressed no interest in being in real estate development. And I would submit that, and we don't quarrel with that finding of fact, I would submit that that doesn't matter for the court's analysis because the company owned a 64-acre parcel in Milford, Massachusetts. The corporate opportunity, as explained by Judge Van Gestel in his findings, was that Lou Frank had begun to pursue an assemblage of these parcels in Milford, and he had focused in on a number of parcels, including Fletcher Granite's own parcel, which it already owned. It was already in the real estate business by virtue of that parcel. He found that Mr. Frank offered to Mr. Pointer the opportunity to join with him in assembling these parcels. That was what was called the outline plan. And Judge Van Gestel finds, very specifically, that Mr. Pointer offered this opportunity while the president and a manager of Fletcher Granite offered no participation to participate in that outline plan to Fletcher Granite or the other managers. Our argument is that once Judge Van Gestel makes that finding, and we apply this court's decision in Demoulas versus Demoulas Supermarkets, a ruling of a usurpation and a ruling of breach of fiduciary duty is required. Because in that case, the court said that before a corporate fiduciary may pursue a corporate opportunity, they must offer it to the company, and the company must reject it. And if you don't offer it, then you've breached your fiduciary duty. Now, how does the judge?
So how much did the managers know about the project?
Well, they didn't know quite a bit. And here are the significant things that they did not know. In the beginning, in 1999, when Fletcher Granite comes together as a partnership and then an LLC, Mr. Pointer joins with Mr. Frank to form a company called Stone Ridge Investments. Judge Van Gestel finds that at that time, Mr. Pointer misrepresented his relationship to Stone Ridge Investments to his partners Castellani and Herbert. He told them that he was going to assist Mr. Frank in selling off the lots in this Greystone site. In fact, from the get-go, he was a 50% owner. And Judge Van Gestel finds that he didn't disclose that and that they didn't learn that until 2004. This is after the employment action had already begun.
But I thought you said you weren't pursuing Greystone.
I'm not, Your Honor. But the connection is this, that when they were told, certainly the owners knew, that Mr. Frank and Stone Ridge Investments were pursuing this Milford assemblage. They knew that there was an attempt to assemble property. They didn't know that Mr. Pointer, the president, their co-manager, their partner, was a half owner of that enterprise. They didn't know that the opportunity to participate with Mr. Frank had been offered to Mr. Pointer because neither Mr. Pointer nor Mr. Frank offered it to them.
Okay, what difference would it make if they had known that he was a half owner?
Well, it would make a tremendous amount of difference, both with respect to the issue of usurpation, but also with respect to the issue of the
So the what?
usurpation.
Oh.
There were two independent claims relating to Milford. One, the usurpation of the larger opportunity to participate in the assemblage, and a self-dealing claim with respect to the specific sale by which Stone Ridge Investment agreed to buy, or I should say Fletcher agreed to sell to Stone Ridge this property. And if I can address that a little in greater detail, Judge Van Gestel makes, very specific findings of nondisclosure relating to that real estate transaction. He finds that, for example, that Pulte Homes, one of the largest residential real estate developers, had contacted Mr. Pointer, the president of Fletcher Granite, and said, we're interested in your parcel in Milford. He finds that Mr. Pointer does not disclose that to his co-managers at Fletcher Granite, but he tells Mr. Frank. He finds that Mr. Pointer unilaterally then extends and revitalizes Mr. Pointer's option without consultation, Mr. Frank's option, without consultation with his partners. He finds that Mr. Pointer tells his managers in late '99, you know, our property in Milford doesn't have much value alone, but in conjunction with this contiguous parcel, which was owned by a separate entity called the H.E. Fletcher Trust, it would have some value. And what we need to do is to get an appraisal to determine what are those two properties worth together. As Judge Van Gestel finds, he obtained such an appraisal. It's called the Crafts Appraisal. And it indicates that the value of the property was $525,000. He finds that Mr. Pointer had that appraisal, that he neither disclosed the appraisal or the value in it, even though this is the exact sort of appraisal he'd advocated they get. He finds that they did not disclose the fact that he and his partner, Mr. Frank, through SRI, had already had a P&S on this other H.E. Fletcher Trust parcel. So,
excuse me, is there any responsibility if Mr. Pointer and told the managers, the partners, that we need an appraisal, then is there any responsibility on the partners to inquire further about whether there has been an appraisal and what the value is?
I do not believe that they were obliged to question Mr. Pointer and say, did you get an appraisal? Did you ever follow up on that? He was, again, the president.
Well, they were aware that he said
they were
we should
certainly
have an
aware.
appraisal.
And my answer to your question, Justice Cowan, is that no, they don't have an obligation to follow up. The facts as found by the judge were that he got such an appraisal, that he had it in hand, that it indicated that the property was worth $525,000, and he did not disclose, again, as found by Judge Van Gestel, that Mr. Pointer pursued the Fletcher parcel on a mission to obtain it at a discount, that he went in and suggested they offer $250,000, even though he knew Mr. Frank was already prepared to pay $300,000. He didn't disclose that he had this additional appraisal, and it was incumbent upon him to disclose that information. It was not incumbent upon the managers to be digging around and investigating and interrogating their president and co-manager about information. They could rely on him to come forward. And I think, Your Honor, that your question puts, brings into sharp relief a really important issue. And why did the judge make all these findings and then yet get these rulings, which I'm urging this Court to reverse? If one looks at the analysis in Demoulas versus Demoulas Supermarkets as it relates to the corporate opportunity doctrine, or any of the cases since then, such as the Genesis case from the appeals court, which I cited to more recently, these cases talk about an obligation of full, frank, exhaustive disclosure on the part of the fiduciary who would try to defend the self-dealing transaction, or the fiduciary who would seek to take a corporate opportunity of the company. It is the exact opposite of the notion that the company has to be digging and looking behind the back of the fiduciary. It's the fiduciary's burden to come forward. Judge Van Gestel doesn't seem to get that.
Excuse me, Mr. Fitzpatrick. Is it clear that Pointer was a fiduciary in that sense?
Absolutely, Your Honor. As the judge finds with, again, very specifically, that from April 99 forward, Mr. Pointer was a manager, member, and officer of Fletcher Granite, a Massachusetts LLC. And then there was no quarrel that he had all of those fiduciary obligations that are the same fiduciary obligations at play in Demoulas versus Demoulas Supermarkets. I want to turn it.
What about his saying, the judge's finding that the company was not engaged in the business of real estate development? Do you answer that, I assume, by saying this wasn't development, this was just selling one of the assets for the best price it could get, as it had sold other assets?
Well, I say
your
that,
answer?
and I say something more, Your Honor, which is that the judge is clearly wrong in his legal analysis when he focuses on what their line of business was. This court, again, in Demoulas versus Demoulas Supermarkets, and many other cases, is abundantly clear that the line of business analysis, which was an old vestige of prior corporate opportunity law, does not apply. That you can't say it's not a corporate opportunity because they're only in the granite business, they're only in the coring business. That's a dead letter, and it was a dead letter when Judge Van Gestel erroneously relied on that analysis.
Mr. Fitzpatrick, I know you're going to want to reach other things, and I'm not suggesting that, I'm not predetermining your determination as to whether or not there was a breach here, but do you want to talk about the forced liquidation issue?
Yes, Your Honor, the Brody issue, and I know that that's of interest. First of all, nobody is, I believe, nobody is arguing to this court that Judge Van Gestel's liquidation order in his original decision comported with Brody. What happened was that
excuse me, no one is arguing that it did or it didn't?
That it did comport with Brody. We contend that it did not comport with Brody. Mr. Pointer is arguing something different now. Mr. Pointer, several months after the judgment and the findings, and while we're waiting to get our transcripts and to proceed, Mr. Pointer brought a Rule 60b-5 motion when Judge Gantz then Judge Gantz was sitting on the bench, and he asked the judge to abandon the relief that Judge Van Gestel had ordered and to order what he called a damages remedy, still calls a damages remedy, but it was pay me what I say my stock is worth and I'll tender my shares. And what we argued to Judge Gantz was that remedy would still violate Brody. It's not permitted under Brody. What my brother and Mr. Pointer have argued in their cross appeal is that, well, we're not going to say Judge Gantz got it wrong. What we're saying is that this court should revisit and refine Brody to create an exception to Brody under circumstances they claim are present, which is that the company is insolvent. And I say the following to that, Your Honor. First of all—
But isn't the claim against the individual people, not against the company?
Well, the freeze-out claim is against the individual people.
Right.
There was a breach of contract claim against the company, and the company was held liable for violating the employment agreement. But the freeze-out—
the freeze-out claim is against the company.
Right. And
so why does the bankruptcy of the company matter? I mean, the freeze-out claim is against the individual, so why does the bankruptcy matter?
Well, my brother will argue that that the relief that the judge had contemplated, a liquidation, which violates Brody, but a liquidation wouldn't do anything for Mr. Pointer because he contends that the company is insolvent. And so he said, change the relief, don't liquidate the company, order them to pay damages equal to what I say my stock is worth. And I don't think the court should do anything with Brody other than leave it exactly the way it is, and I say that for three reasons. First—
Well, let me just ask you, if I understand relief might not be ordered, but if it is, what do you say what is the appropriate relief here?
In this case,
Yeah.
if the court is not persuaded,
I
as we
understand.
argue,
Yeah.
then the relief can only be consistent with the reasonable expectations that Mr. Pointer had. And the only reasonable expectations he had that have been arguably frustrated, we dispute that, is his right to be employed under his employment contract. Judge Van Gestel gave him all of that relief. Judge Van Gestel, on counts 2, 3, and 5 of the amended judgment, which were for breach of contract, covenant, and interference—
In other words, he shouldn't have been frozen out. I mean, he shouldn't have been dismissed.
Well, he was dismissed,
Yeah.
but what's the remedy if it was improper?
Yeah, that's what I'm saying.
And what I'm saying is that by ordering him to be paid, which the judge did, through the term of his contract, which was through 2006, that's all the remedy he would be entitled to. To then, in addition to that, say, and on top of that, we're going to liquidate the company where there's no reasonable expectation of that as a remedy, we say that violates Brody. But important to my argument, Your Honor, is this, which is that because he had an employment contract, the analysis begins and ends with the employment contract. That he, under blank versus Chelmsford OBGYN, cases like Marola and others, all cited in our brief, that if a person, as part of a closely held entity with all the Donahue rights he's entitled to, if he enters into an employment contract, which, like this one, contemplates termination without cause, contemplates termination with cause, and is not a lifetime contract, that he cannot get a remedy which tries to give him lifetime employment.
Well, that would violate Brody, wouldn't it?
It absolutely would, Your Honor. Judge Van Gestel violated Brody. No one's here to tell you he didn't.
Van Gestel did what?
He violated Brody
yeah.
by ordering the liquidation of the company. But what's more, Your Honor, that the only breach that he ruled that happened here was that Mr. Pointer's employment was terminated. That's the breach. He wasn't denied participation as a manager. There was no other thing that happened to him.
But then, so you're saying there was no freeze-out as a factual matter?
As a factual matter, what I'm saying is that if you take the facts as found by Judge Van Gestel and you apply the correct law, there was no freeze-out. Judge Van Gestel found that Mr. Pointer did all of the things that the defendants fired him for. He found that he had made
Okay, but I think
If
the
you
Chief's
think that,
question
if
is...
there were a freeze-out, then
Yeah.
what remedy do you give?
If there was a freeze-out, the only reasonable expectation he could claim to have had was to his employment through the end of the term of his contract. The judge granted that relief by ordering $320,000 of contract
But
payment.
he didn't he had ownership interest.
And he still has his ownership interests, and he still is a manager, and he still gets financial information. There is not a finding, my brother will tell you otherwise, but there is not a finding anywhere in the decision where one can find that there was anything that the defendants did that falls within the gambit of alleged freeze-out other than as
Terminating.
relating to his employment. So we contend, first of all, that on the facts found, he needed to be fired. It was clearly appropriate that under Wilkes, which talks about the need for the majority to have some freedom to act appropriately, even though they have fiduciary duties, they acted appropriately. Their decision to fire him was supported. And again, coming back to where we started, they suspend him in March of 2004 when he refuses to discuss with them his illegal political contributions and other misconduct, walks out of the room. And once he's
Okay,
suspended...
but those illegal political contributions, I mean, that does sound like a made-up after-the-fact issue, because the company had always made those, according to the findings.
Well, that is correct. However, Mr. Pointer ran the company. To say that Mr. Pointer had always done it...
You're going backwards.
But I am, yeah. All right, go ahead, I'm sorry.
Well, in any event, after he's suspended, he sues them and discovery commences. And they have to go into his files. And they discover what he had not told them about Milford. They discover that he'd been a 50% owner. This is the basis for the judge's finding that they didn't learn that until 2004. They discover all the nondisclosures relating to Milford, the outline plan. And they discover that Mr. Pointer, in violation of his contract, has been operating this real estate venture relating to Milford. His contract specifically said he was not permitted to engage in anything other than SRI, which was a different entity. So I know my time is over, and I thank the court for its indulgence.
Thank you, Mr. Fitzpatrick. Mr. Kelston?
Good morning, Your Honors. I represent Mr. Pointer and the Stone Ridge entities. I was going to begin with the freeze-out, but I think I need to begin with Milford.
Well, why wasn't this a business opportunity that belonged to the company?
Your Honor, let me begin by reviewing what the judge found, and then I'm going to review all the information that was disclosed by Mr. Pointer. And in fact, there was voluminous information disclosed about Milford. And the company and the defendants...
Disclosed that he was a 50% owner?
It was disclosed that he was an owner, that he was a manager and
It was it disclosed, I repeat, was it disclosed that he was a 50% owner?
not a 50% owner, Your Honor, but an owner and a manager. Nobody asked
Did he
him.
disclose the value of the appraisal?
Yes, it was, Your Honor. There were 4 appraisals. The first was for $170,000. It's referenced in the September 1999 board minutes. The second was Mr. Castellani's appraisal for $192,000. The third was Mr. Pointer's appraisal for $385,000, provided at the board meeting in October when they decided to sell. And the fourth was the Kraft's appraisal, as to which Mr. Castellani testified. The question, and this is in our brief, excuse me, did Mr. Pointer give you this appraisal? The answer was yes. Now, Judge Van Gestel had a huge record in front of him, 700 exhibits and 23 days of testimony and no transcripts. He made a mistake on the Kraft's proposal. When we got the transcript and we put it twice before the court in our briefs, Mr. Castellani said, I got that appraisal. Let me review
Mr. Kelston,
now.
can I just ask you this?
Of course, Your Honor.
The initial action against your client was to terminate him, correct?
Correct, Your Honor.
He had a contract,
Correct, Your Honor.
and it was for a limited term.
He had an employment contract, Your Honor, but much more than that.
He was terminated.
Correct.
What other action was taken against him?
Your Honor, here's the actions that were taken against him, and I think these are very important. Remember, first of all, he's the largest owner of the company at 43%. He's the largest investor.
No, I just want to know what actions were
I'm
taken.
sorry. In late 2003, this is a man who has the most money in the company, and he runs the company. He's a manager for life under the operating agreement. In late 2003, Mr. Castellani and Mr. Woodbury secretly communicate with Mr. Maurer, Exhibit 592.
He's a manager for life?
Yes, Your Honor. As long as he's an owner, he's a manager. He's identified in the operating agreement as a manager for life. As
What
a
is the
key
difference? So what does the employment contract do for him?
The employment contract is
Is
the
every,
operating
is every owner a manager?
no. The original 3 owners are managers,
Right.
and they can remain managers. The operating agreement identifies the president as a person who runs the company, and it has a
Right, but he remained a manager after he was terminated as president, correct?
He was, Your Honor, but he
Right.
is. Let me go through, in fact, then what happens in answer to Chief Justice Marshall's question. In late 2003, Mr. Castellani and Mr. Woodbury secretly negotiate with Mr. Maurer. They write him a letter. They say that Mr. Pointer, while not devoid of strengths, is stubborn, hard to control, has made some bad decisions, and they say the company's poised for great growth. Now, at this, there's no criticisms of Mr. Pointer at that time at all. Now, in February 2004, remember, this is a manager of the company. This is a man who has run the company essentially for 15 years. In February 2004...
But he was running the company for 15 years as manager or as president?
President, Your Honor.
Under the employment contract?
No, he ran the original Fletcher Granite. He formed the LLC in 1999, and he runs that. And the operating agreement provides that he will become the majority owner of the company through acquiring stock. In February 2004, Mr. Castellani and Mr. Woodbury...
So they write this letter, so they've done nothing to him. The 2000 letter, they've done nothing to him. They've written a letter.
I'm sorry, Your Honor.
In the 2002, they've done nothing to Mr. Pointer. They've written a letter to a third party.
No, there's nothing that happens between 1999 and 2004. In 2004, they hire Mr. Maurer as the CEO, secretly, without conferring in any way with Mr. Pointer to replace Mr. Pointer. They make Mr.
As
Maurer...
president, right? As president.
They hire him... There is, as the leader of the company...
I mean, does that go to the employment contract, I think is going to be the question.
They call him the CEO, but he replaces... There's no question he's hired to replace Mr. Pointer. Mr. Pointer is a 43% owner. There's no notice to him that this is happening at all. They make Mr. Maurer a manager of the LLC secretly without talking to Mr. Pointer. What do they give Mr. Maurer? a generous salary and benefits. But here is what else they give him, and this is all in Exhibit 592. A promise of 20% of any future growth in the company. That's a company owned 43% by Mr. Pointer. They're going to give Mr. Maurer secretly 20% of any future growth in the company. And they write in his employment agreement that we shall use best efforts to get for you, Mr. Maurer, 49% of the company, i.e. all of the stock in the company that Woodbury and Castellani don't own. All of that stock, they're going to get that from Pointer, and they're going to give it to Mr. Maurer. Now, when Mr. Pointer objects to the stock, and he does that on February 6, 2004, within a month, this is what the defendants do. They suspend him from employment. They do this all on March 30th. They bar him from the company, suggesting if he comes to the company, he'll be arrested. This is a company he has come to every day for 15 years. He's still an owner and manager. They bar him from the premises. These are all in exhibits. This is not testimony. These are exhibits. They tell employees and third parties that he will not represent the company, even as a manager of trade associations. They remove him from distribution lists. They download his computer. Then what they do at the same time is they take a vote to value his stock and buy his stock from him, all on the March 29, 2004 meeting. The appraisal is terminated. They don't offer him anything for his stock except 1/3 of the book value. And when he turns that down, they fire him for cause. A year later, they sue him and spend $1.4 million pursuing him in a lawsuit. 43% of that $1 million is his money. You can't imagine a more thoroughgoing freeze-out than what happens here. His professional life is taken away,
Mr.
his
Kelston,
employment.
let's assume we agree with you. What is the appropriate relief now?
Your Honor, the appropriate relief now, I think, has to be payment of the value of his stock. Judge Gantz found in October 2008 that the company is now insolvent. What's been taken away from Mr. Pointer is his employment. You can't...
Yes, but again, I'll ask you, why can't he get his remedy against the individuals?
He can, Your Honor.
So
It
what
has
is
to be. Your
Okay,
Honor,
so what does it matter if the company is insolvent?
Well, no, but the relief has to be from the individuals because the companies, he can't get his asset back. That's gone. Just in terms of the companies and
I thought that he asked for the liquidation. Didn't he ask for the liquidation of the company?
No, Your Honor. What he actually said, Judge Gantz ordered a possible liquidation.
You mean Judge Van Gestel?
Ginger and Gestel.
Do you mean Judge Van Gestel when you talk about possible liquidation?
Yes. He had an alternative order. He said, look, he said to the parties, negotiate a buyout.
Right.
If that doesn't work, then we'll sell the company. But if the appeals or SJC doesn't like that remedy, then I'm going to return Mr. Pointer to running the company with back pay. The problem is, and what we say in our brief is, as an alternative relief, return him to the company, but the problem is the company is virtually gone. The company sold its Chelmsford Quarry. That's 80% of its production. All of this is in the record. They sold it for $6 million, and they're under agreement to sell the remaining 10 quarries for $4.5 million. $10.5 million to sell a company whose bank debt only, is $16 million and has been. So the company's gone. You can't return him to employment. You can't give him back. He invested everything he had in this company.
So what is the relief that you're looking for?
I'm sorry, Your Honor.
You're looking for to the payment of the value of his stock, but the stock has no value at the moment.
It would be the value of his stock at the time he was frozen out, which would be December of 2003. December of 2003.
2000.
And Your Honor, I think...
But would that violate Brody? Because it would put him in a better position than if he had stayed with the company and the company had gone bankrupt. His stock would be worthless.
Your
So
Honor,
I'm asking you, would that violate Brody?
Your Honor, I think it doesn't violate Brody. Brody says a buyout remedy in footnote 7 will not be generally available. We want to return you to the position you would have been in, but for the breach. But for the breach, he would have remained running the company. He would have remained and become the majority owner of the company, and he would have controlled his asset. Now, he was removed from employment, barred from the company, taken off the distribution list, so he had no role in the company.
I mean, how would he have controlled his asset? He was a 43% owner.
He was a 43% owner. Running the company, he has control over his asset.
But there's 57% of other people. 57% of the company is owned by other people.
Yes, absolutely, Your Honor.
So he
but-
would not have been in control of the company. He was
Yes.
a minority shareholder.
No, Your Honor, under the operating agreement, Mr. Pointer must be mentioned a dozen times by name under the operating agreement as the key executive and as the person who has all of the options to acquire the majority ownership of the company as the older investor owners become incapacitated, pass away, or decide to sell their stock. So there's no guarantee, absolute guarantee he'll become the majority owner, but there's an almost certainty he will, and it's everybody's expectation that he will. At some point, he becomes a majority owner. But you have an asset, Your Honor. It's worth, when he's frozen out, $3.6 million. He can't-
Excuse me, sorry, Mr. Kelston, I don't mean to interrupt you. The 3.6 is the value of his 43?
Of his
Okay.
asset. Now, he can't convert that to cash at that point. He can't convert it to cash. But it's worth a great deal. It is his whole life. He can borrow against it. It can be collateral for him. It gives him standing in the industry. And at the very least, under the operating agreement, the company or the individuals are required to buy his stock at book value when he dies. So at the least, he has an asset he can leave to his family. He's frozen out. He loses all management in the company, and then existing management. And we're talking about 2005, 2006, 2007. When the business is going great, they destroy the business. They lose $3 million in each of 2006 and 2007, most of the value of the company. Been no audited financials for the company since 2006. The company is a shadow of itself. They decided to kick him out of the company. Doing so, it seems to me they have to assume the risk that if his asset is impaired and disappears, that they have to pay for that. It's not his risk, it's their risk.
Don't you, let me just ask you this about last question on remedy. Given what you say, accepting what you say, that the circumstances have changed dramatically since Judge Van Gestel's order,
Yes, Your
as
Honor.
reflected in Judge Gantz's 2008 decision, wouldn't it be appropriate, consistent with Brody and the sort of range of possibilities that Brody suggests, if you prevail, that it get remanded for another, how can we order a remedy?
I agree. Your Honor, that's completely right. In our first brief, we said order him $3.6 million. Now, we agree. The case would have to be remanded to see if, in fact, to see, one, what his value was when he was frozen out, and two, if there is any effective remedy short of buying back his stock. And we agree to a remand. Your Honor, I know I'm running out of time, but I want to talk briefly about Milford. And I think probably the
Let
most...
me ask you this on that subject. The judge found that one of the company's businesses was the ownership and disposition of real estate assets. Do you agree with that finding?
No, Your Honor. That was referring to the old Fletcher Granite Company, not the new LLC. The new LLC only quarried granite pursuant to the operating agreement. And I'm going to identify...
But it had some real estate that it sold off at various points.
That's correct, Your Honor.
And so wasn't its aim to make as much money from selling off these assets?
It did, and Judge Van Gestel found that the sale of the Milford 300 acres, of the 64 acres for $300,000 was a commercially reasonable price. I'm going to
But how
refer...
could that, but is that finding warranted? Given the fact that you have an appraisal for so much more, that when the property was put together with the other property and was ultimately sold by a developer for $6 million?
No, Your Honor,
3 years
on the
later.
$6 million, nothing was ever sold for $6 million.
Combined parcel, the combined 450-acre parcel.
No, there was a purchase and sale agreement that was executed in April 2001. I'll refer the court. That's Exhibit 109. That was to sell a portion of this assemblage to the Gutierrez Company for $6 million. It didn't include the Milford Fletcher granite land. If you look at Exhibit 109, you'll see that the purchase and sale agreement calls for a closing in 4 years if permits are obtained for 545,000 square feet of office space. The last 2 pages of Exhibit 109, you'll find extension number 14 to the purchase and sale agreement. It never closed. There is no dispute in this case that no money was made from the Milford transaction. In Exhibit 726, Mr. Pointer, in 2006, when the real estate market was strong, offered to sell at his cost without a penny of profit the Milford development to the defendants or to the company. He said, it's ill-advised, don't do it, but if you want it, you can have it. They had no interest in it. And, Your Honor, if I could point out, here are the exhibits which show the disclosures that were made. Just one thing. Attorney Antonellis,
Mr. Kelston, we are running out of time. I know that your brother had a couple of extra minutes, but don't waste the time by giving us the exhibits. You can send us a letter if you want to list us the exhibits.
Okay, Your Honor, I actually, I'll send you a letter identifying those exhibits. And what I would say about those exhibits is I'm going to identify 7 of them. They told the defendants everything they needed to know, which was, we've got to sell Milford. It's going to be sold as part of assemblage of properties. SRM is going to buy it, and I, Duke Pointer, am a partner in SRM. Nobody asked any questions. All they wanted to do was sell this abandoned, dangerous quarry in which there had been a drowning death in 1995, and the company had not been able to sell it, and they were as happy as they could be to unload this extremely dangerous piece of property. And I will, in a follow-up letter, identify just 7 exhibits which show complete, full, and adequate disclosure of everything having to do with Milford.
Thank you, Mr. Kelston. Let me make sure that the post-argument letter is not an invitation to make another argument. Dear Chief Justice Marshall, here are the 7 exhibits, 1, 2, 3, 4, 5, 6, 7. Okay?
Agreed, Your Honor.
And if counsel wants to say, but if you're looking at those, you should look at 1, 2, 8, 9, 10, 11, you could do that. But it's not an invitation for another round of briefing. I'm sure your clients will be delighted to hear they're not going to have to pay you for another brief. Thank you, Mr. Kelston. Thank you, Mr. Fitzpatrick.